Where should you keep your original will or trust? The answer may surprise you slightly. Before we get there, I'd like you to think about a friend of yours who's struggling with a what-if scenario that creeped into their lives, but they were somewhat prepared because you shared our video. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we can help some folks along the way. Now, technically these days, the copy of most documents is going to be acceptable outside of the last will and testament, which is of course used at someone's passing if they own assets in their individual name. The original will have to be presented to the court. So all other documents, however, even an electronic copy, will be sufficient to handle your matters after you finalize your plan. However, it is good to have those original documents on hand if they are needed for any purpose. Now, ideally, your attorney has a method to safeguard those documents, such as in a fireproof cabinet, as well as a method to coordinate with your trusted named parties when the time comes to provide them with a free discussion to review what was created, how it all works, and what needs to happen next to make sure your wishes are followed through with. Now, if your attorney is missing either one of those, right, a method to keep it safe and a method to coordinate the people with the information they need to have, then it may be in your best interest to maintain those original documents in, again, a safe way for precautions against water or fire of any kind and those types of damages, potential damages. However, I would encourage you to make sure that your trusted parties, your family members, whoever you've designated to be in charge of those decision-making at the relevant times, have access, obviously know where the documents are, and have access to those documents. Otherwise, what can happen, and I've seen this many, many times, is we get a phone call and we have no idea where original estate planning documents are, right? Or even worse yet, the old attorney decided that they were going to retire, they became ill or passed themselves, and there was no follow through. So that would actually say a third point for your attorney is that they have to have a plan, especially if it's a smaller practice, as to where your files will go and how they'll be handled if something happened to them. So 3 points. 1, they have a secure way of holding them like a fireproof cabinet. 2, they have a method of coordinating with your trusted parties to discuss what was created and how to implement it. And 3, if something happens to that attorney, especially a smaller practice, they have a method in place as to how your matter will be transitioned, the original documents, to another firm or back to you as the client. So we hope that you've learned something here, something new here today, and that you choose to share. And as always, please take care.